Hello, this is Vivian Young with 1000 Friends of Florida. I wanted to welcome you all to the first webinar of the year, Planning for Sea Level Rise, Legal Issues Facing Florida. We have a little bit of housekeeping to take care of, and then we'll jump right into the presentations. 1000 Friends of Florida, for those of you who aren't familiar with us, is a statewide not-for-profit organization, and we were founded in 1986. And we focus on saving special places and building better communities. We encourage you to sign up for our email alerts, which are at 1000friendsofflorida.org/alerts, and you'll get information on upcoming webinars and other events. We also encourage you to make a donation or join us at Donate Now, and we're also on Facebook and Twitter if you'd like to find out more about our activities. First of all, we'd like to thank the sponsors for the Dr. John M. DeGrove webinar series. A special thanks goes to our Florida patrons, the Archibald Foundation and Mosaic, the President's Club sponsors, our Cobb and Cole. A special thank you to Kimberly DeGrove, who is the daughter of Dr. John M. DeGrove, who, as many of you know, is a very special person in terms of planning and growth management in Florida. We also want to thank the Perkins Charitable Foundation, the William Howard Flowers Jr. Foundation, as well as our sponsors, the Florida chapter of the American Planning Association, Ronald Book, Dover Cole & Partners, Kitson Evergreen, Tallahassee State Bank, and Thompson Brock Luger & Company. For those of you who are seeking credits, this webinar has been approved for 1.5 legal AICPCM credits for planners, and the information number is there. It's also been approved for CLE credits by the Florida Bar, for contact hours for certified environmental health professionals, and for credits for certified floodplain managers. For everybody on the line, about an hour after the webinar, you'll receive a follow-up email, and it includes a link to SurveyMonkey, and we encourage you to give us feedback. We really do read it and pay attention, and it helps us shape future webinars, so please take a moment to do that. I wanted to tell you a little bit about our upcoming webinars. On February 11th, we're really excited to have Victor Dover. For those of you who are not familiar, and I'm sure there's not too many of you who aren't, he's a very noted planner who has done incredible work. This is his latest book, Street Design, The Secrets to Great Cities and Towns, and he's going to be focusing on Florida-specific examples of good street design, and I think it's going to be a really exciting webinar. You can go to our website at 1000friendsofflorida.org /webinars and join. I realize I don't have the link here. And then on March 11th, we have our 2015 Florida Legislative Update, where we'll be providing an overview of the major planning and conservation initiatives coming up before the Florida Legislature. Both of those are on our website, and I think I've got the link later. I just realized I don't have it here, so we encourage you to sign up for that. Florida, 1000 Friends of Florida is a 501c3 not-for-profit, and we rely very heavily on donations. We encourage you to donate to 1000 Friends at the link here. If you would like your donation to support the webinars in particular, you can allocate your donation to the DeGrove Education Fund, and we appreciate all the support we can get. Just a little bit of housekeeping for this specific webinar. If you go to 1000friendsofflorida.org, you can download the PowerPoint for this webinar. It will be updated. It won't be for Sea Level Rise. It will be for the legal issues. And it's under the What's New category. You can click on that. We have two versions of the PowerPoint. One is the version that you actually see on the screen, and a second is more printer-friendly with all the background colors and information taken out. If you have sound issues during the webinar, we do everything we can. We do sound checks. We try to adjust things, but it is still not the most sophisticated system in the world. So we encourage you to adjust your speaker on your computer up or down a little bit if you have problems. Some speakers might be a little louder than others, and you can adjust their level here. You can also go to your go-to training panel and do a sound check, and you can do a little bit more fine-tuning there if you wish. The other thing I wanted to mention for this webinar, if you click on the materials box, that will maximize that box for you, and it'll have a drop-down menu. We have the two versions of the PowerPoint loaded there. One is, again, the version that you're actually seeing now. Another is printer-friendly. Richard Grosso also put together an excellent background paper, and there's a link to that included there as well. And finally, there's a link to 1000 Friends of Florida's climate change page, which has a lot of useful information on it as well. At the end of the webinar, we open it up for questions. The way you ask questions is you have a chat box. You click on, it'll be a little plus sign on yours. You click on it, it will open it up, and you can type your question in here. You can either send your question to the entire audience or to the organizer, which is me, and we will ask as many questions as possible at the end of the webinar. We do ask that you try to keep your question fairly succinct, so we can answer it, fairly easily. We ask that it not be too specific to one particular piece of property in one particular community unless it has some relevance for, people throughout the webinar. And again, we try to answer as many questions as possible, so we encourage you to, throughout the webinar, send your questions in. And if it's directed towards a particular person, if you could say a question for Richard, a question for Aaron, and we will direct it appropriately. As I mentioned previously, we have a climate change page on our website. The way to get to it is to go to 1000friendsofflorida.org. If you don't want to type this whole URL in, you can click on Building Better Communities and scroll down to Climate Change. It'll bring this page up. And under New, it has the background paper that Richard Grosso developed, as well as the PowerPoints for this presentation and a lot of other information. So we encourage you to go there. And as an aside, we're always updating that page. So if you have more information about Florida-specific plans and studies, please send it to me at vyoung@1000fof.org, and over the coming weeks we'll be happy to load it. What I'd like to do now is turn the presentation over to Charles, and he's going to talk a little bit about the present.
Thanks, Vivian. This is Charles Pattison. I'm the Policy Director here at 1000 Friends of Florida. Today we have three of the state's leading experts on the legal ramifications of sea level rise and climate change on Florida communities, and we'll hear their insights on the challenges and options for local governments here in Florida that are facing these challenges. First up is Richard Grosso. He's the Director for the Environmental and Land Use Law Clinic and a Professor of Law at Nova Southeastern University. He teaches land use and environmental law, Florida constitutional law, and directs the Environmental and Land Use Law Practice Clinic. He has 28 years of experience litigating and advocating on various issues and specializes in land use, growth management, and environmental policy and permitting issues. Richard's the former Executive Director and General Counsel of the Everglades Law Center, former Legal Director for 1000 Friends of Florida, and attorney for Florida Departments of Community Affairs and Environmental Regulation. He's represented numerous clients over the 28-year span of his career, including public interest clients in the state of Florida and federal and state administrative and judicial proceedings. He'll be speaking on the legal issues impacting sea level rise in Florida communities. Next is Thomas Rupert, a coastal planning specialist with Florida Sea Grant. He's a licensed attorney, and his work focuses on hazard mitigation, post-disaster recovery planning, environmental protection, marine spatial planning, and associated long-term challenges and opportunities for Florida's coastal communities. His areas of expertise include beach and coastal policy in Florida, Florida's coastal construction control line permitting, comprehensive planning law and sea turtle habitat protection, the Endangered Species Act, coastal and maritime permitting programs, and Fifth Amendment takings law. In addition, he has worked on Clean Water Act, total maximum daily load program issues, water quality trading, low-impact development, stormwater, homeowners association, and boating law issues. Thomas will be speaking on specific Florida legal cases. Our last speaker is Erin Deedy. She's president of Erin Deedy PA, which is a full-service legal and consulting small business administration, federally certified woman-owned firm. She is a licensed attorney, a certified land use planner, and LEED AP certified as well. Her practice focuses on public sector government representation and also includes numerous private sector and ag interest clients. Her practice includes water, energy, climate, environmental, local government, administrative law, and land use issues. Her experience includes litigation, public finance, special purpose governmental creation and representation, as well as land use planning. She's authored 8 sustainability or climate plans for local governments throughout Florida, and is a frequent lecturer and author on climate change, energy, and public finance issues statewide and nationally. She will be speaking on local government responses in Florida to sea level rise. So we'll start with Richard Grosso and look forward to the program.
Okay, I think that's my cue, right? So thanks, everyone, for being here. Okay, I'm going to assume everyone sees the same screen I am, and I will move forward. I think
Richard, this is Vivian. Yeah. I just wanted to remind you, you need to go over to slideshow at the top of the screen, click on that, and do from the beginning, and that'll show it in the slideshow format.
Okay, I think I've done that.
It's still not showing up that way. Try it one more time. There we go.
All right.
Okay.
Okay. I think that the key point I would make to begin with is that zoning is the most powerful tool that exists relative to sea level rise preparedness and hazard mitigation. I think when you look at the big picture of the entire body of environmental and land use law that exists in the country, all the federal laws, environmental permitting laws, state environmental permitting laws, and local government authority to plan and zone, to designate every parcel of land, not just uplands, not just wetlands, whatever, I think that makes local government planning and zoning decisions not just the most powerful tool for local governments for sea level rise preparedness, but I think it's the most powerful legal tool comprehensively that exists for any level of government anywhere in the country. You know, he or she who has the power to determine how an area is going to be designated and zoned really is he or she that defines its fate, decides its fate. Because sea level rise preparedness is all about where we build, how much of it we build there, and what the standards are for building. Hazards are going to be there. They're going to increase. Storm surge, sea level rise, erosion. They're surely getting worse. They're not getting better. The most effective, the most fiscally and otherwise efficient approach is to avoid them in the first place. You know, it's clear doctrine of environmental permitting law that environmental permit agencies don't get to decide, was that a smart decision to plan for a subdivision there or a shopping center or a whatever. Only local governments have that authority to decide where to avoid urban, suburban, intense development, where to direct it. And so maximizing that authority is the key to any governmental response. Okay, so that moves me then to the sort of the specifics of Chapter 163. There are several key aspects of the basic legal requirements that I think directly relate to sea level rise resiliency. Number one are the data and analysis requirements. I would point out that professionally accepted data and analysis to be based on that means to react to it in an appropriate way, and I think this is important, to the extent necessary as indicated by the data and the analysis. I think at this point, January 2015, given the enormous amount of sea level rise, storm surge, hurricane erosion science data that's out there, I think it's going to be hard, increasingly so, for land use decisions, plan amendments to be approved, comply with the law without taking that information into strong consideration. I think it's probably not going to be possible to ignore sea level rise and related data because of how ubiquitous it is and how strong it is. The other point about data and analysis is that plans can be based on at least a 10-year planning time frame. I think it's really smart to do that. I would make a point about this, though. You see a lot of debate and discussion about should we be planning 30 years, 20 years in advance, 30 years, shouldn't we be looking at 100 years? I think in an ideal world, you look at 50 and 100 years down the line and you base decisions on that. But in the real world, there's limitations on the accuracy of the information the farther we go out. There's surely limitations on the policy, the political, the public taste to be making decisions based on 50 years from now or 100. I think if local governments are making really smart decisions based on 20, 30-year projections, 15-year projections, depending on the nature of the area and the information, and you're putting yourself in a position where 5, 10, 15 years from now, you've done a good enough job of getting yourself that far, and now you can make even better, stronger decisions, that's probably the best we can do in most cases. So you don't want to reach too far because of the limitations, but obviously you've got to look to the future information, and as science gets better, increasingly there is information there to be very useful. The next slide, the future land use element, I've already pretty much made that point that, I mean, this is legal authority when you look at the details of the statute that simply exists nowhere else for any other agency. This legal mandate that all land use decisions be based on the suitability of the land relative to things like the character of the land, the availability of water supplies and infrastructure, soil suitability, topography, natural resources, obviously the sea level rise, susceptibility of an area fits clearly within the ambit of those requirements. Before I get into any of the more detailed requirements or provisions of Chapter 163, I want to stop and really emphasize a set of key points here about how powerful a legal tool a comprehensive plan is. The legal authority to say that's the kind of land use there, at what intensity, and what the standards are. When you look upon the factors that are supposed to inform that decision under the law, this is a classic statement of what planning is all about. Some of those are objective, some of those are subjective. It is the highest level, the courts have said, of legislative policy decision-making that an elected city councilman, county commissioner, whatever, has to weigh and balance the engineering stuff, the ecological stuff, the social, the cultural, the economic, all these quantifiable and unquantifiable subjective factors, and then weigh and balance them, make priority decisions, and that's how you decide what the land use is and what the density is. The courts have said clearly that's the highest level of policymaking, highest level of legislating. In other words, the thing that a court of law is most going to be hesitant to overturn or second guess, because when they do that, the court is now violating the separation of powers doctrine. It's usurping the legislative power of a local government. So when you, and there are cases in Florida that have upheld strict growth limits, like numeric caps on how much development can happen, where the numeric cap was one number that they got from maybe a hurricane evacuation study or a transportation study. And the local government defending that in court was able to say, you know what, there were other factors too. There were non-quantifiable things that were growth limits. We just couldn't quantify them. So, for example, we used the numeric things as a reasonable approximation or proxy of those other things. And the court said, you're right. We can't second-guess your judgment on that. It's not arbitrary. It had some basis in planning rationale, so we're going to uphold the law, or the ordinance. We're not going to overturn it. So the very nature of what a planning decision is makes it, again, in my view, the most discretionary decision any governmental agency can make. And so surely, my message is that local governments, where justified, where necessary, where appropriate, ought to very much maximize the use of that discretion, because when you try to make highly discretionary decisions at the permitting level, when you try to say, oh, kind of, oops, wow, we never should have planned or zoned that area for that intensive development in the first place, but now let me try to make a really strict permitting decision to kind of make up for that inherently flawed land use, that's a heck of a lot more troublesome. That's a heck of a lot more difficult. So you want to get it right the first time with the discretion you have at the planning level. The next set of key implications of that, I think, relate to the obvious issue of private property rights. Because one could say, okay, you may have the legal discretion to do all these things, but surely private property rights are going to come into play and limit that discretion, and surely that is true. Everyone has to live by the Constitution, and you have to live by the Harris Act. But I think some key under or misunderstood legal points about property rights are important to point out. Number one is that there is no property right to any existing planning or zoning designation. And so where the science is telling you the existing plan designations, the existing limitations on development and standards no longer make sense, they are no longer appropriate, given now what we know about sea level rise, storm surge, etc., local government is surely justified against private property rights to reduce the allowable uses, to ratchet up the development standards. So long as you're not pulling stuff out of the air and it's irrational, arbitrary, and capricious, where there is any valid planning or scientific or engineering rationale to do that, local government may do it. The private property right that landowners have is that there's a limit to how much of an impact that change can have. Under the Constitution, if that change is so drastic that there's no longer an economically viable use of the private property, then that's a taking. You can't go that far. The Harris Act standard is a little more liberal for landowners. It's an inordinate burden standard. If the change is so great that it's an inordinate burden, you can't do that. Most changes are not going to violate those standards. I know Tom can talk more about it, but to dispel the notion that there's a private property right to the existing zoning, only if they've actually vested rights, expend a lot of money based on the existing law, only then do they have a vested right. The other thing that's much clearer, that's much easier, is there's no property right to an increase. So step one for any local government is where people ask for increases in land use or intensity or decreases in the standards. If the science at all suggests that is probably not a great idea relative to sea level rise issues, saying no to that it's almost virtually impossible for a landowner to win a lawsuit saying you had to change the rules for me. There's no property right to have the rules changed, to have land use density increased. And there's a really specific case on the down zoning or the down planning that I've identified here, both the Glisson case and the Lee County versus Morales cases, like directly related to sea level rise related issues. That is a strong case that strongly supports changes to existing designations and standards relative to the kind of issues that are implicated by sea level rise. So I'll move now quickly to some of the more detailed requirements of the Act. Huge overlap between the requirements relative to infrastructure elements and sea level rise, and I would most immediately point out the section in the statute that requires plans to limit public expenditures that subsidize development in coastal high hazard areas. Again, taking that back to private property rights, there is surely, this is clear, and this was really reiterated recently by the United States Supreme Court, which I think all agree is very much a pro-property rights, relatively conservative court, a very strong statement that there is no property right to any manner of public subsidy. There is no property right to the first dollar of a public subsidy. There is no property right to having the laws allow any off-site impacts. Given private property rights, given dwindling budgets, given difficult choices to make about where you're going to build infrastructure, where you're going to protect infrastructure, Not subsidizing development, again, is one of the, in the wrong place, is one of the easiest, most legally defensible things local governments can do. Moving to the protection of wetlands. A key distinction I would make between a local government planning authority and that of wetland permitting agencies is the idea that I mentioned earlier, that a local government has the authority to look at all of the land, wetland, upland, the mosaics, where water meets the land, etc., and make appropriate land use decisions based on that. A local government's planning authority is not narrowly defined to, wetlands or endangered species habitat or that kind of thing. One of the biggest issues with sea level rise is habitat migration, is allowing there to be enough land for wetland habitats to move, for beaches to move, for water-based habitats to migrate. Local governments have all the authority they need under Chapter 163 to identify those areas where habitats are probably projected to need to shift, and write plans and development standards that make sure that there's going to be enough open space preserved, that those habitats are not going to butt up against concrete when they try to move and shift. That's a really important function. The law very much requires you to direct development away from wetlands, but not just wetlands. Again, any suitability-based land use decision that might be looking at the need to protect future wetlands, future water-based habitats as they migrate, is a really important function. Moving to coastal management, obviously a huge overlap between the detailed requirements there, and it's the coastal resources issues, and very much it is the human safety, the hurricane evacuation limits. I'll make another point about private property rights here. There's a sliding scale that courts look at when deciding how far regulation can go before it violates private property rights. It's not a hard and fast rule. In most cases, it's a sliding scale. The more important the governmental objective, the farther it can go in regulating before it's going to be viewed as a taking. Protecting damage, destruction of life and limb as hurricanes approach is going to be at the highest level of governmental imperative. So where comp plans are having strict limits on coastal development or water-based development based on evacuation and public safety, you can demonstrate that and you can emphasize that. That is a strong defense to legal challenges. Adaptation action areas, they are obviously specifically authorized as an optional thing, but I would make a key point about that as the last point I make on my PowerPoint slide. Adaptation action areas are authorized for very specifically defined areas, but that is surely not to the exclusion of all the other legal authorities I've been mentioning, the ability to look at non-coastal areas that are subject to sea level rise and plan appropriately based on their needs. I think putting the adaptation action area thing into the statute a few years ago was good. I think it focused a lot of attention and brought about a lot of technical support from DEO, but certainly it's not to the exclusion of the other things that we're talking about. Before I shut up and sit down, I want to mention a couple of special considerations. The first is cumulative impacts. I think the key point there, the scientists tell us ecosystems already stressed because of pollution, bifurcation, fragmentation, other development impacts. If ecosystems already under stress, it's far less able to respond to climate and sea level rise-based impacts. I think that puts much more of an onus then on fidelity to the requirements in the law of considering cumulative impacts, and puts much more onus on protecting natural resources from the garden variety human-induced, human-made impacts so that they're more resilient to those climate and sea level rise changes that are fixing to come. I would make the same basic point about open space. As much intact, large open space as you can maintain gives beaches, coastal habitats, freshwater habitats, much more room and resiliency to respond to sea level changes and other related changes. The next point that I would make is, over the next two PowerPoint pages here, is that the huge issue is always about, hey, the science is uncertain, the science is disputed, we can't absolutely predict these things, my expert disagrees with county staff, so you can't regulate on that. It's a very acute issue with sea level rise and climate because of the nature of those issues, that it is a decades-old issue in any environmental or land use regulation. Courts have said for decades, science is uncertain. That's the nature of the beast. Debate, uncertainty is not an excuse for not regulating. It does not prevent government from regulating. All that is required is that there is science. If there's disputed science and folks disagree with what the local government is doing and the science the local government is responding to, as the local government will win. As long as there is valid science, planning rationale, engineering rationale, scientific basis, it's not arbitrary. As long as there is valid science, courts are going to defer to the local government. A court is not going to act as a super PhD scientific panel and say, oh, I'm second-guessing your science. I'm going to agree with the expert of the people who oppose what you're doing, local government. It's just the opposite. The local government's science will be given deference on these issues, and the courts have said, where you got uncertainty, and you almost always do, you exercise the precautionary principle, the be safe, the be cautious principle. And that has been blessed by the courts. Therefore, it is the best valid public policy where you've got scientific uncertainty. So I think I've already talked about private property rights a lot. I'm probably up on my allotted time, and so I will leave it at that and be happy to answer any questions later on. No, I'm not done. I want to focus you on this final advice. A couple of things. A premise in the case I've made here is that local government has very strong legal authority for what it's doing. I do not articulate that. I do not emphasize those points so as to suggest we should be willy-nilly, draconiously, is that a word, regulating and planning all private property. I think you should be working with the private sector, with landowners, to come up with agreed solutions that are necessary and appropriate and make sense. But you need to do that as local governments from the standpoint of knowing what your regulatory and planning legal authority is. I say that because I see too much, a lot of folks in government don't know the full extent of the legal authority that government has to regulate. You should know that. You should understand it. You should proceed from that assumption. But surely you ought to find good strategic changes that can be implemented politically, locally as well. And the final point I'll make is that the best solutions are always place appropriate. Try to translate the general information to site-specific. One size fits all. If that's the best you can do, fine. But to the extent you can do place-based regulations and planning designations, that's always going to be more legally defensible and more politically defensible. So that's my final advice. Thank you. I'm done talking now. Can anyone hear me? All right? All right.
Okay, Richard, thank you very much. I'm busy behind the scenes changing screen controls here. I'm going to mute you, and Thomas, you should be on the line right now, so we're ready to proceed with you. Thomas, can you hear me?
Can you hear me?
Yes, we can.
Very good. Well, thank you, Vivian. I'd like to say thanks to 1,000 Friends of Florida and to all for putting this together, and to all the attendees. Next slide. So just a quick overview of what we want to look at today. Start with some of the potential sources of liabilities, then look at, I think, what I draw as some of the lessons from this, and talk about some of the options that local governments have. Next slide. So the first scenario for potential liability I'd like to look at is issuance of permits in hazardous areas. Now, this can be distinguished from the scenario where local governments issue permits that cause increased flooding to existing development. Now, there's clear legal liability for that, but the question then becomes whether local governments can be held liable for issuing permits to build in areas that they have strong evidence may flood or be impacted by sea level rise, but then go ahead and issue those permits. under current law, if a property owner were to make a claim against a local government for having permit in that situation, they're probably not going to win. However, many commentators have begun asking if at some point the foreseeability of increased flooding due to sea level rise could eventually result in that type of liability when the local government, again, doesn't inform the permit applicant. While, as I mentioned, this is not the law right now, laws do change. I think the one example most people can relate to is the tobacco litigation. 20, 30 years ago, I don't think most people could have imagined that tobacco companies would be paying out billions of dollars to willing users of their product. But of course, that's what happened as both scientific and cultural, scientific understanding and cultural norms changed. In any case, even if local governments do not become liable for knowingly permitting an area that is likely to flood from sea level rise, the local government will likely still have to address many of the increased infrastructure and services costs associated with that type of development, and we'll get into that a little more later. And while local government is not currently held legally liable for permitting development that later suffers from flooding or other coastal hazards associated with sea level rise, just as the local government might have known it would, it's still not very good policy to do so. Local governments now, as Richard kind of mentioned, have so much information available to them about the different risks to different properties that property purchasers really should be warned about these different types of hazards that they face. And this is not only an increase in fairness to the property purchaser, but it might also have some longer-term positive legal implications for local governments that we'll talk about a little bit later. And next slide. And now we have another scenario where liability is somewhat unclear. What happens if a local government can no longer realistically maintain infrastructure that, if voluntarily abandoned, would violate property rights protections? This question was addressed in the Jordan case. And you can see a picture of some of the land at issue in the Jordan case. This is just south of St. Augustine, and on the left side of the picture there you can see State Highway A1A. And originally it was built in the 1950s right out on the beach towards the right side of the picture there. And a little red arrow just indicates where the former roadway has washed away entirely. But even though it was built in the 50s, is just a few years later, the state was dealing with so many erosion problems undermining the road that the state purchased new right-of-way where the current road is on the left side there and moved the road west. And then in 1979, there were 3 homes on the about 1.6 miles of the old right-of-way for the road. And that right-of-way was given to St. Johns County. And then the county started receiving applications to build homes along that 1.6-mile stretch, and they started issuing those permits. And by the time the road, big chunks of the road had washed away, and by the time litigation hit the courts in about 2005, there were 20-some homes along the stretch of road. So really, arguably, the first big mistake there was permitting homes along that stretch of eroding road. But over a several-year period, the counties, over a 5-year period from about 2000 to 2005, the county spent $2.3 million trying to take care of this segment of road, which came out to an average of almost $250,000 per mile per year versus an average cost for their county road maintenance of under $10,000 per mile per year. So they were spending a lot of money on that road. And next slide. And this is, what it looked like even during that time. So if you notice here, you can see that the road is to the right, or to the right of those power poles. Next slide. And here, that's looking the same direction. So if you look to the right of those power poles there, you can see that there's not a lot of road bed left there. So anyway, at the trial court, the property owners claim that the failure to, quote-unquote, maintain the road there deprived them of access to their property and therefore was a taking of their property rights. The county won quite easily at the trial court level. The county argued that We have the legislative discretion to make decisions about how we spend our money to our road maintenance funds to maintain our roads, and we've spent a lot of money on that road, and we can't do more than that. And so the trial court agreed with that, and the property owners were unhappy and appealed that to the 5th District Court of Appeal. And the 5th District Court of Appeal said, yes, you do have a lot of discretion, but it's not absolute. And they set down the requirement that the county had to provide a reasonable level of maintenance that resulted in, quote, meaningful access, unquote. And I leave it to you to decide, how you can do anything reasonable that's going to result in meaningful access in this type of situation. But eventually the case did settle, and essentially the settlement result in the county making a good faith effort to maintain the segments of road as they were and to aid in some sort of access to an easement to get to properties that no longer had any road left. Next slide. So that Jordan versus St. Johns County case, in my view, really should kind of frighten local governments if they're going to be on the hook for spending virtually unlimited amounts of money to maintain infrastructure in the same functioning state regardless of the changing situation represented by sea level rise or other coastal hazards. Does this mean that local governments have to bankrupt themselves to do this? And if the answer is yes, then local governments need to find a way to move people away from these areas so that the infrastructure costs don't bankrupt them. But how do you move people away from some of these areas before the full damage strikes and costs you all this money in infrastructure? You can try to buy them out voluntarily or exercise eminent domain, but neither one of those is going to be very popular or even financially feasible. So it really led me to ask, is there any way that local governments can escape liability for infrastructure non-performance that could dramatically lower the attractiveness and value of property or even potentially drive people from their property? And so this brings us to this last scenario about drainage. And while if you don't upgrade drainage, I initially put no legal liability, and then thinking a little more like a lawyer, decided I'd cover my bases and say it's just very unlikely. But there will be, of course, tremendous political pressure to continue to upgrade drainage structures and drainage systems that are now underperforming due to sea level rise. Next slide. So since we're already seeing increased flooding due to sea level rise affecting stormwater systems, a colleague and I wrote an article examining whether local governments might be legally liable for that flooding if they don't alter existing stormwater systems to account for sea level rise. Next slide. And what we realized is that while local governments have very broad authority to engage in drainage activities, there is actually no responsibility or requirement that they do so. What this means essentially is that if you're a local government and you've already started providing drainage in an area, you have to maintain that and you have to maintain it reasonably. But if you haven't started providing drainage in an area, you're not obligated to do so. And even though there is this obligation to maintain what you've already put in, arguably in Florida here, there's not a duty to upgrade that drainage. And the analogy there would be with roads. It's very clear under Florida law that local governments are not required to upgrade roads as long as they are properly maintained. So if there's just simply not enough capacity, it's not, from a state law perspective, required that those have to be upgraded. And I've seen case law in other states that applies that exact same reasoning to drainage, but have not yet seen that case specifically here in Florida. So you might kind of ask, well, why the difference? And it goes back to one of the things that Richard mentioned, which is the separation of powers is one of the reasons. Again, these types of decisions about where to invest money in upgrading systems is specifically a duty of the legislative branch of our government. So it's really not for the courts to be coming in and saying, oh, you have to do this. On the other hand, when you're doing kind of operations, or day-to-day maintenance of a system, there's always that duty to act with reasonable care, and that applies to local governments as well. So while you might have a legal out here, no one is going to be very excited about seeing property owners slowly abandoning areas because of persistent flooding impacts, but this might be one of the only ways that people will ever move out of harm's way without the public, through you as local governments having to foot the entire bill. So unless we come to better solutions, this could be a really ugly default. Next slide. So if local government is so often left kind of holding the bag for legal and financial responsibilities with impacts from sea level rise, what should you be doing? Here I'll just highlight some of the options that can help reduce local government liability, moving generally from those least likely to provoke a takings claim to those that may provoke a takings claim. Next slide. So now I've gone and mentioned the dreaded elephant in the room of takings, and Richard talked about it a little, and I'm certainly not going to take you to law school here, but these 12 little words in the Fifth Amendment to the U.S. Constitution have been at the heart of many legal battles, and this creates a lot of important context for us. So the one thing I just really did want to point out right now is that most of the takings claims that you deal with are what are called regulatory takings claims if you're dealing with land use planning, or inverse condemnation claims. And the majority of these, if they make it to a court, they're going to be examined under the three-part test. Richard mentioned one part of it, the nature of the government action. But the part that I want to emphasize, and we'll talk about later, is how the regulation affects what's called the reasonable investment-backed expectations of the property owner. So we'll come back to that in a bit. Next slide. So the first thing, before local governments worry about what their citizens are doing, arguably they should first worry about what they themselves are doing and get their own house in order. I think a great example of this is Miami-Dade's recent resolution R45114, and this recent resolution in Miami-Dade requires that all infrastructure projects consider sea level rise. I think that consideration of sea level rise, I'm assuming it will also apply to the siting and not just type of construction. One of my worries is that throughout my work I've consistently seen great emphasis on how we build in hazardous areas, but much less often is there any discussion about where we develop, depending upon the coastal hazards such as sea level rise and surge and erosion. Next slide. So if local governments want to go one step further beyond getting their own house in order, they could start to inform people about sea level rise and some of the coastal hazards and the resulting regulations that stem from these hazards. They could do this through two different methods. First, they could require that notice be given to potential property purchasers. The state of Florida supposedly does this through the statute cited here, 161.53, but research has demonstrated that just due to the poor drafting and execution with this statutory requirement, over 85% of property purchasers don't recall receiving any notice about these coastal hazards. So it's very ineffectual. However, it can be done much better. This is not a given that it has to fail this way. Second, local government could also provide notice to permit applicants of hazards related to their property and associated legal limitations that either exist now or that might actually change in the future due to the changing nature of the hazards. Neither of these options raise very significant risks of successful taking claims against government, so that's still a big benefit of these. Next slide. But notice could potentially have some impact on takings claims for regulations that are related to coastal hazards. So I had mentioned that three-part test and the reasonable investment-backed expectations in takings law. So the question then becomes, might a court that knew a property owner had extensive information about the hazards that have given rise to the regulations think differently about how reasonable some development expectations are compared to a person that could argue, well, I really didn't know about any of these hazards and their extent with regards to my property. it's by no means a given that this would make a huge difference in a court's analysis, since every regulatory takings claim is examined on its own merits, but it's certainly a possibility. And it's interesting, you can go as a local government even one step further than just requiring notice, and you could require signing of what's called an assumption of the risk. And basically this would just be, say I ask for a permit in this area and the local government, like St. Johns County did or was going to do with permit applicants along the eroding road, and say, well fine, we'll give you a permit to build there, but you assume all the risk of the hazards that exist there. And again, St. Johns County was going to begin doing that with applicants for permits, but the court in that case said, the trial court where the county even won, the trial court judge called this policy repugnant, and I thought that was very surprising in light of the fact that this is not an unusual policy. Next slide. In fact, St. Johns County had done its homework quite well, and they were aware and had documents showing that this is exactly the way the California Coastal Commission puts language into their permits, and they require basically assumption of the risk by the permit applicant. So it is pretty interesting that California is doing this, whereas a trial court judge here in St. Johns County is calling it repugnant. Next slide. And yet one step further, you can begin to prevent hazard-prone development. You can see some language here from Chapter 163, Florida's planning law, and it really indicates that in theory you should already be doing this. And I'm sure most local governments, you have language in your comprehensive plan that is either the exact same or very similar to this language. And I've seen that in many, many comprehensive plans. But the question that I always want to ask then, is it really implemented, and how and where? Where does this policy come through in your code or your development code? Next slide, please. And you might also think that, well, maybe you don't have to do this at the local level because isn't the state doing this through the Coastal Construction Control Line permitting program? And I mean, after all, that program you can see right here, it's supposed to protect Florida's beaches from imprudent construction. Well, there are, next slide please, there are a number of problems with the Coastal Construction Control Line. There an excellent analysis by a private consultant. I did one myself here of the program, and a lot of shortcomings of that program. One of the most obvious ones, of course, is that it only applies to the sandy shorelines of the state. Next slide. But rather than try to walk you through the excruciating details of how the laws and regulations of this program fail to live up to what you might expect, sometimes it's easier to just look at the pictures of what gets permitted and what happens. So in the lower right there, that one might be a little harder to see what's going on there, but those little holes you see, that's the top of the dune has been scraped off, and that's where they're going to put in the pilings for the house there. Next slide. Another couple good examples of what's permitted. Next slide. And one of my personal favorites, where you've got the support columns for a house going in on the wet sand beach. And I think if you as a local government see these pictures, you need to keep in mind that while the state may be allowing this construction, you have to as well. And the first entity that's probably going to feel pinch from legal or financial responsibility for the challenges that these properties represent, it's usually going to be you as the local government. Next slide. So that brings me around to the end and kind of the summary and lessons. I think you're really looking at, when you're permitting some of this risky development, potentially in the future you are now going to be saddled with the maintenance costs for the infrastructure for that development, because you can't just simply say, nope, not going to do any more for you. Historically, local governments have had the idea or mentality of avoiding legal liability by allowing property owners to do what they want so that they avoid the risk of a takings claim. But increasingly, what we're starting to see is as you accrue other types of liability, potentially further limiting development might not always be the worst of your financial battles. You can do several different things that to help avoid some of this. One, provide notice. That one, there's just no risk in doing that, essentially, except unless the political risk, but legally and financially there's not that much risk. I think the most obvious one in my book is to just lead by example by you as local government doing things very well and considering sea level rise in all of your public infrastructure decisions. Great way to start, and then begin to move into those strategies to minimize development in risk-prone areas. So thank you very much. That completes my presentation, and turn it back over to Vivian.
Thank you, Thomas. If you bear with me, I'm going to be switching control over to Aaron now. Okay, Aaron.
Okay, so I'm going to go ahead and start, and I think I have hopefully a little bit of a different perspective and some case studies that I can bring to this discussion to get people thinking about different policy and regulatory issues involving sea level rise, but in a different way. I always like to kind of start with terminology, flooding, sea level rise, storms, whatever you want to call it, because in each jurisdiction you're going to deal with this terminology in different ways, and there's going to be different reactions to it. So I like to start out with this picture. I call this Martin Luther King Drive in Escambia County versus the Dodge Avenger, and that is my Dodge Avenger, and no photo credit is necessary because I took this picture the day after floating down the street in Pensacola after the rains in April earlier this year. And, you know, interestingly, sometimes it takes an event to kind of start this conversation going, and I have to give a shout out to Escambia County staff for picking me up that night and rescuing me. But sometimes these events and this terminology, it needs to shift and it needs to evolve to actually start having this conversation in a meaningful way. So here's another example, October 2012, Royal Palm Beach. You know, why should you care about planning for sea level rise? And that's kind of part of the conversation that we're having right now. You've got some of the legal implications, and the landscape is changing. And Richard and Thomas talked about some of the liability and some of the evolving law around this, but I would put forward that you kind of got a confluence of things. You've got those liability issues, policy issues, but you've also got new data and treating that data in a new way, in addition to the different legal implications. And I love this quote from Winston Churchill. I think it's very apropos. It's having the capacity to react to that data that's really important and is going to drive us to better decision making. So I like to take a step back and look at all the different ways that climate change is popping up in regulatory decisions, case law, and in different ways that we're accustomed to. We're seeing climate change crop up in NEPA decisions and evaluations and rules, Endangered Species Act, Clean Water Act, right down to different cases about how a local government can adopt green building codes and how far can you go in regulating vehicle emission standards. I'm going to talk a little bit about some of the money damages and insurance. Thomas and Richard both touched on those issues, but I'm going to provide a couple of examples there. And I always like to end on kind of a interesting, unique case, and this time I'm going to end on a protester's case, which is kind of an interesting area of the law that's evolving also. So I've been monitoring this database out of Columbia Law School. They have not updated the number of cases in this database. Unfortunately, we're still operating off of that 2012 number. But the take-home message is there are a heck of a lot of cases out there that are evolving climate change and sea level rise and these issues on some level, and that number is not reducing. That number is increasing significantly. So one case I'd like to talk about is post-Hurricane Katrina. It was a suit by property owners against the U.S. Army Corps of Engineers for failing or mismanaging what we love to call the Mr. Go, the Mississippi River Gulf Outlet Project, essentially parts of the federal levee system that failed. And at the lower court level, because of the Corps' quote-unquote negligence, these plaintiffs, some of these plaintiffs were awarded $720,000. Now, that was appealed and that was overturned on the basis of sovereign immunity. The case was pushed all the way up to the Supreme Court level, and they declined to act on that case. But what it is, it's a signal. And just this morning I was reading a case in New Jersey, post-Sandy, where property owners were suing the local drainage districts and trying to establish that it was the mismanagement and the lack of maintenance on the system versus just a huge amount of rainfall that was actually the cause of their damage. And that's where, you know, these cases become more difficult because it is a confluence of things that lead to these damages many times. The new case, and this is kind of how some things are evolving, we like to call this the new elephant. I've had these conversations about this case numerous times with Thomas. This is a very interesting one. Property insurance companies, they sued over 200 local governments and drainage districts outside of Chicago, arguing that they sustained economic loss from the mismanagement or lack of control and operation over that system. Now, one of the theories of the case was that these drainage districts and local governments knew that this was a problem because they had adopted the Chicago Climate Action Plan and failed to implement portions of that plan in a timely manner. So they knew or should have known that climate change was real and that these high volume rain events were going to become more of a future condition. And the interesting thing was they withdrew the case 2 months after they filed it, and their quote in many of the newspaper articles is, "We made our point." And their statements are that, you know, we feel confident that this has raised the discussion to the point where these local governments will act accordingly in the implementation of different parts of this Chicago Climate Action Plan. So, you know, insurance and apportioning liability for failure of systems is something that local governments, water management districts, the Corps of Engineers, drainage districts should all be aware that, again, these cases are coming when we're starting to try to figure out who's to blame for the failure of infrastructure to keep up with these changing conditions. So we talked a lot about Chapter 163, but Florida also has some other interesting things. We've got a state goal on greenhouse gas emissions, vehicle emission standards that were adopted in state executive orders that were not repealed, by the way. We did that research. Changes with House Bill 697, where we were requiring greenhouse gas emission reduction strategies in 4 different elements of the comprehensive plan. Now, some of those mandates have been revised. Richard has mentioned adaptation action areas. So we have a little bit more than just 163 as a potential tool that kind of shifts the wind, so to speak, in terms of trying to start dealing with climate change and energy policy in the state. When I go work with a new local government, I typically try to tell them that the debate is planning for future conditions, but just to make sure that everyone's on a level playing field, taking a look at what's happened in the past and acknowledging that climate change and sea level rise are actually real conditions. We like to use the Key West Tide Gauge. It's one of the oldest sets of data that we have that shows in the last 100 years we've seen approximately 9 inches of sea level rise. And even in the conversations that I have in different jurisdictions, this tends to be eye-catching because it diminishes some of these more cyclical arguments and, you know, antecedent conditions and all of that other stuff. We just look at what's happened over the last 100 years, and it tends to normalize the discussion somewhat. A lot of the work that I'm doing right now stems from the work that's been done by the Southeast Regional Climate Compact and their projections of 2030, 3 to 7 inches, and 2060, 9 to 24 inches of sea level rise. And for consistency standpoints, in one of the case studies I'm going to talk about, we've used those same same projections. One thing that I've also realized in talking to local governments, and the question just came up in our chat room, how do we deal with longer-term planning horizons beyond just 20 years? Getting beyond 2060, the discussion becomes difficult because local government decision makers, staff, it becomes their problem. It becomes a much further out, much more future kind of condition to deal with. But I find that when you talk about 2030 and 2060, you tend to get a lot more response from people because they can almost see and feel those dates. Just the other day, 2030, hey, that's 15 years away. We're dealing with 3 to 7 inches. That could be a real impact to a lot of local governments and infrastructure and habitat that we're talking about. So we've run in the Monroe County and the Isla Mirada projects that I'm working on, we've run these 4 scenarios, and in certain times we've run Hurricane Wilma-like conditions to give people a preview of what's going to happen when to their habitat and infrastructure. Other planning considerations, Thomas has started to refer to insurance. Insurance is going to be a limiting factor. It's going to control some of our affordability considerations with housing and where people live. And I also like to tell people that planning is not just a good thing because of this confluence of liability and policy and law and that type of thing, but FEMA, if you're not familiar, has its community rating system program, and local governments that mitigate and reduce risk for exposure to events and things like that, they get better scores in this community rating system, and that translates into discounts for national flood insurance community-wide. And the types of planning that we're talking about here, better data, better elevation data, making better decisions, outreach, those types of things directly translate into points and a better score within FEMA's community rating system. So again, if whatever is your angle to kind of help this discussion along, reductions in national flood insurance premiums is definitely one to consider across jurisdictional boundaries. So what is a good approach to planning? First, you obviously have to understand your infrastructure vulnerabilities, and this is the most important piece. And talking with a colleague today, data is really important, and the state of the data in developing that vulnerability analysis is hugely important. Some people find it, oh, I don't want to talk about data, I want to kill myself because it's boring, but data is the whole key to anything in terms of having a good solid infrastructure or habitat vulnerability analysis. You address your near-term vulnerabilities first, look at what's going to be impacted in 2030 or those earlier years first, minimize new problems through appropriate planning, and making sure that these concepts of resilience, whatever the terms of art are that work within your discussion, making sure that these are a core concept of all of your projects' decision-making and intergovernmental coordination across departments. And then, the other side of the equation is obviously trying to be a leader in reducing your carbon emissions and mitigating the overall problem that's driving sea level rise and climate change to begin with. So an example of what different local governments or Florida governments are doing, we're seeing more and more comprehensive plan elements addressing climate change. I've seen it in 2 different approaches. One, addressing it through a new element, a separate element, like an optional element within your comprehensive plan, or addressing it through multiple elements, your existing elements and your coastal element in your comprehensive plan. More and more communities are looking at freeboard initiatives requiring additional elevation for structures above base floor elevation. This is one of the key things that helps people gain points in that FEMA community rating score program that I talked about. Capital improvements planning, funding of capital improvements planning, the Miami Beach example that many of us in South Florida are aware of, and the work that they've been doing to retrofit pumps and infrastructure. Regional initiatives are becoming more and more powerful. Depending on where we live, as we come to this call, we may have heard or participated in one of these regional initiatives, but these regional initiatives are very important because they're providing sources of information, data, and tools that smaller local governments or individual local governments may not have the capacity to develop at this point. And then local government planning, I've seen a myriad of approaches to this, data collection being very key. The stimulus grant money drove a lot of local governments into sustainability and energy efficiency planning. A logical progression of that is planning for climate change and sea level rise. Many local governments are starting to really look at their vulnerability. And then finally, adaptation planning. When you have all this data and you know what your vulnerabilities are, what can you do? And what is the return on investment of those potential solutions? So this is just a quick little schematic of kind of a process that I try to utilize when approaching a resiliency planning effort or climate change or whatever you want to call it. You know, define your project area. It may be large, it may be a subset, it may be a neighborhood. Look at your existing conditions, because obviously we don't want to keep exacerbating the mistakes and the problems that we're already seeing occur. Identify priority issues. I mean, what is your priority? Is it to figure out how your roads will be impacted, your drainage, that type of thing, developing your planning and then implementing and monitoring. And within Florida, a good way to take this is you don't want a static plan that sits on a shelf. You want to integrate this into your comprehensive plan and your code, which controls your long-term and your short-term decision-making in regards to infrastructure and land development. So this is Chicago after that Farmers Insurance event. And the question becomes, what kind of data do you start collecting? And I'm going to talk a little bit about the Green Keys project in Monroe County and the Islamorada Matters project, and give you kind of a snapshot of some of the information that we've been collecting in that vulnerability analysis. You know, one of the first things you want to do is you want to understand what your increases in nuisance flooding are. And this kind of timeline shows, obviously you can see where this is going. We used 30 years ago, we used current year, and then we used the 2030 and the 2060 scenarios. Now, of course, you know, you look at this and you say, oh my gosh, flooding at 24 inches by 2060 over 600 times a year, how can you do that? Well, you have 2 high tides a day, and a lot of this nuisance flooding is going to be driven by those tidal cycles, and we've seen more of this in April and in October with the spring and fall high tides, but you're going to see increases in this nuisance flooding, and you want to know what that means for your local community. We utilized FDOT's sea level rise sketch tool and looked at what the road impacts were going to be within Monroe County. This is just a 9-inch scenario in Big Pine Key, and shows the red dots show where that particular roadway network is going to be vulnerable in the future. This allows you to help better plan your road paving and capital improvements projects to deal with those vulnerabilities in the future. This is a schematic of 7 inches of sea level rise in Lower Matecumbe, which is a kind of a choke point for US 1 within Monroe County and Islamorada. And this could be very well a more current and more ongoing condition of seeing wet areas right up against this section of US 1. We utilized the USGS integrated surface water groundwater modeling tool to determine what the well field impacts. I'm sorry, my circle there is a little off in terms of FKAA's location, but we found that in terms of groundwater supply wells, that the Keys was probably going to be in pretty good shape in the 2060 time frame, believe it or not. And resources for planning. There are a heck of a lot of resources out there. NOAA has great tools that you can utilize online to get some of this nuisance flooding impact evaluation. The Nature Conservancy's Coastal Resilience tool. I mentioned the FDOT tool. I try to create a chart here to show you what data is created and how that will help you make decisions. And the Corps and through FEMA and NOAA have a sea level rise change calculator. So this is also a scenario that we ran. This was within Islamorada. That after you have this data, the question becomes, what do you do with it? And as a I call it a thought exercise. We looked at 3 different adaptation strategies. And the first one, elevate and flood-proof, what we did was look at the properties that were not already elevated and flood-proofed within the village of Islamorada, and without any damages, with damages, if we employed that particular strategy, what could we avoid? And the interesting thing was, costing out these different strategies and looking at how much damage we can avoid. When you evaluate that, elevate and flood-proof looks like a very good strategy in terms of being able to avoid a lot of real estate damage within the community. We also looked at constructing breakwaters in front of the most vulnerable locations and then voluntary buyouts. When we costed out what those strategies were, again, elevate and flood-proof became a high and a low-cost estimate for those. They're high-dollar strategies. But at the end of the day, when you evaluate the return on investment of these particular strategies, anything of a benefit-cost ratio over 1 is good. And as you can see, with elevate and flood-proof, because so much damage was avoided by employing that particular strategy, the benefit-cost ratio is very good. Now, that's not to say that the Village of Islamorada is going to go out tomorrow and find $100 million to implement something like this, but if there were a grant to become available to assist property owners with elevating and flood-proofing, they would have a priority. They would know what properties were the most vulnerable, and they would know that this was a cost-effective strategy that may be worth putting match in or pursuing grant dollars or that type of thing. So this is the type of adaptation planning and the type of scenario analysis that I see us kind of going towards, or the move that we're going to be heading to get better information to make better decisions. And what those decisions are about land acquisition, and not just land acquisition, but managing the land we have so it's not infested with exotics and able to provide some level of adaptation and mitigation benefit. Policy implementation, that departmental collaboration is key in implementation through the comp plan and the code. Make it a goal, make it a policy, and then make it the law. And then finally, project planning. We know that there are going to be more budget implications with these types of things. It doesn't necessarily that those are going to be higher, but they're just going to be different considerations. So in tying this to the capital improvements or the land acquisition programs that a local government has and making better decisions on that data is really, really important. I'm winding up. I have 2 more slides, but I like to have people consider other issues on the rise in terms of sea level rise and climate issues that we haven't really thought of. We've talked a little bit about those extreme rain events and who's liable when the drainage systems fail. Tom's talked a little bit about armoring renourishment. We've talked about property rights issues. But those bottom 3 are really important in my mind. In Florida, we're fighting either we have not enough water or we have too much water, but those fights over water, when we start considering precipitation patterns in the future and whether we're going to have less or more precipitation because of climate change and sea level rise, water rights and scarcity are going to become big, big issues. Responding and rebuilding after a disaster. How do we rebuild? To what standards? Hurricane Andrew changed the playing field in terms of wind mitigation and how we build regarding wind disasters, and are we going to see more of that in terms of resiliency planning? Immigration and refugee issues, and it sounds a little lofty, but it's really not. In speaking with some colleagues today, when we start retreating from our coasts further inland, we are going to be pushing more people, and as we're balancing population growth, into areas that are already built. And what is that going to mean in terms of the people that are living there? Property values, insurance rates, making sure that new construction is built to a resilient standard. So we're not just dealing with international immigration issues, but we're dealing with immigration issues within our own states and within our own counties. And so, as promised, I'd like to end on an interesting case, Commonwealth versus Ward and O'Hara. And these are two lobstermen in Massachusetts that they used their boat to block the shipment, a coal shipment, into this power plant station. And what they did was they claimed a necessity defense. They said, climate change is so important. We were driven to this action because nobody was listening, and this is such a clear and imminent danger that if we don't do something about our fuel policy, if we don't start looking at these climate change issues, then we're really going to be in trouble, and we've got no legal alternative. And there were many, many charges against these two people. In October, the district attorney dropped the conspiracy charges and changed the other charges down to just civil infractions and fined these guys about $2,000. And the district attorney basically said, look, I agree with these guys. This is a grave crisis, and we really need to start talking about this in a more meaningful way. So here's a picture, and that little white boat off to the right there is their vessel of Warden O'Hara. So I like to end. We've got to consider these things, and we've got to kind of rise faster to the challenge than the sea level rise we're dealing with. And I'm going to go ahead and stop there for some questions.
Okay, thank you so much, Erin. We appreciate your presentation, and I'm going to go over a few housekeeping details again, and then we will get into the question and answer period. Again, for those of you who arrived late, the PowerPoint is available on our website at 1000friendsofflorida.org under What's New. It has been updated. It's not the Broward County one. It's the current one, so we'd like to encourage you to go there to see it. Again, if you continue to have sound issues, you can lower your volume and you can adjust, do a sound check on the webinar. If you do have questions, and we do have a number of them in already, you can click on the chat box. If you click on the little plus sign next to chat, it'll maximize it, and you can type your question in here. We will answer as many questions as possible and try not to run over too much. Again, as a reminder, this webinar has been approved for credits for planners, Florida attorneys, certified environmental health professionals, and certified floodplain managers. I also wanted to mention that an hour after this webinar, you'll receive a follow-up email, and it'll have a link to SurveyMonkey. And we'd like you to take a few minutes, if possible, to answer a few questions. We really do use your feedback to help shape our future webinars. 2 more webinars coming up that we're going to be offering on February 11th. We're really pleased to have Victor Dover on street design, and on March 11th, 2015, our very popular 2015 Florida Legislative Update, where we will give you an overview of planning and conservation legislation that's on the horizon. Again, we have loaded a lot of our information on climate change. If you go to our website and click on Building Better Communities, you'll pull it up. There were some questions about the Department of Transportation sketch tool that Erin mentioned. We do have a link within an earlier PowerPoint called Planning for Sea Level Rise, State Resources. I will, over the next week or so, try to pull a lot of that out and put specific links in. I'd also like to say, if any of you in the audience know of other plans and studies and policies that are Florida-specific that we should post on that page, please let me know, and I'll send an alert out next week with the updated page and all the links and information that has come in for us. Finally, 1000 Friends, as I said before, is a nonprofit, and we appreciate donations and support to allow us to be able to provide these webinars at such a low cost, and we hope you'll join us for future webinars. Whoops, didn't mean to do that. At this point, I'm going to open up all the other speakers and start asking some of the questions that are listed. And we do have a number of them, so we'll do our best to answer as many as possible. We'll go back to the beginning. We have a question for Richard. If you can't deprive a landowner of economic use of property, then is it true that zoning is not a tool to force coastal retreat or prevent people from building on an extremely erosive beachfront property? And I think you had talked a little bit about comp planning versus zoning, but I was wondering if you could go over that again.
Okay. I'm not entirely sure exactly what that's asking. You can replan and thus then rezone private property to a large extent, but the limit on that is where you've had such an economic impact on the landowner that under the Constitution there's no longer an economically viable use, or under the Harris Act there's an inordinate burden, whatever that means, because the courts haven't really told us, although it's pretty clear it's something close to the constitutional standard but different. I think if you're asking if doing what you need to do on that parcel of land would violate either of those taking standards, are you now powerless to do anything? And I would say in that situation, that's when you've got to be looking either at land acquisition, if it's that important, or a variance. And I'll make this point. I think codes and plans ought to be written as stringently as possible without regard on their face to takings problems. The way you handle takings problems is you put into your comp plan and you put into your code a waiver opportunity that says if any landowner can demonstrate that the application of the generally applicable policy would violate their property rights, then in that case we are authorized to hereby grant a waiver or an exemption to the extent necessary to avoid violating their property rights. That's far superior to dumbing down your rules to avoid takings. Give yourself an administrative out. I hope that answers the question.
Okay, thank you. We have another question that I think Aaron touched on, but I wanted to see if Richard and Thomas had some perspectives on this. The planning horizon for comp plans is only 20 years in the statute. However, many of the impacts of sea level rise are not anticipated to cause significant impacts until 2050 and beyond. What would you recommend to those local governments wanting to begin the discussion and set the stage for adaptation action in the future? Aaron covered this, I think, in great detail. I just didn't know if Richard and Thomas, if you had any other information that you could add to that.
I think you do a couple of things. First of all, it may very well be that the existing science, the existing knowledge of the next 10 years worth of data and sea level rise tells you need to be making some changes. I also would deem it a smart idea to put language in your comprehensive plans and your zoning codes that specifically acknowledges that these provisions, these allowances, are subject to change in the future as more data comes in, that sort of thing. The more you're putting people on notice that your laws are dynamic, that they are subject to change related to the new science, the better. And then the final point I will make is that if the data is saying these impacts, the situation is going to look like this in 40 years or 30 years, if you're permitting today structures that are going to have a lifetime that extends into that period, then you are on perfectly valid ground for your rules that govern that construction that's going to be around several decades now.
Yeah, this is Thomas. I would follow up on what Richard was just saying and emphasize that while the statute may only require 20 years for planning, that is by no means a limitation that local governments cannot do more. Many local governments have done planning exercises that go much further out than 20 years, and that is what I would argue the local government should do. And in order to generate the political support for that, what they need to begin to do is relate sea level rise impacts to impacts that are occurring now and to issues that are currently relevant to their constituents, things such as flooding, drainage issues, the National Flood Insurance Program's increased costs. There are ways to generate some support for this.
Vivian, this is Charles. One other thing we didn't mention in Chapter 163 is the mandatory 7-year reassessment, the evaluation and appraisal report of all local comprehensive plans. I would say it's incumbent upon DEO to have local governments at least on a 7-year basis address this issue in some fashion.
Okay, thank you, everybody. We have another question. I think this would go to Thomas. In the St. John's case, couldn't the county argue that its right-of-way was lost and the mean high water line had been moved by an act of nature?
Well, arguably the county did try to do this and say that the road was taken by nature rather than natural forces rather than anything the county did. But the 5th District Court of Appeal said that even if the county didn't actually do anything to cause the loss of the road, the 5th DCA kind of made some really tortured use of some past legal cases to claim that an inaction by the local government could lead to a taking. And the 5th DCA also kind of tortured some previous cases to get to the idea that there was a duty to maintain that road despite what was going on. And so if you argue that there is a duty to maintain the road and that the county, through its inaction, didn't maintain the road, then that's the way the 5th DCA was potentially getting the liability for the county.
Okay, thank you. Thomas, I think this would be for you as well. What are the disclosure obligations for an existing homeowner and or realtor who's selling a coastal property?
Well, for the homeowner, there's actually just a form that they fill out, and it doesn't, and it includes things such as whether or not you've had plumbing problems and whatnot. But for the realtors, arguably, the realtors have a fiduciary responsibility to their clients to inform them of anything that materially affects the value of the property. Do they either know or even believe that this materially affects the value of the property, and does it materially affect the value of the property at this point? I mean, surprisingly, you look at a lot of places, even up areas that were affected by Katrina, and in some places there hasn't been as much impact on property value as a rational person might have expected after such an event. So at this point, there is nothing that really requires realtors to give any sort of notice other than the notice that's required via the statute I mentioned in my presentation, 161.53. And again, that's buried in that stack of paperwork, a couple inches thick, that you go flip through and sign on a bunch of pages.
Okay, thank you. We had a question about posting the Miami-Dade Sea Resolution link, and Thomas has provided that information. We'll again post all of that on our updated climate change page over the next week and send the information out to everybody. We have another question, and I think if any of you want to jump in, maybe we'll ask Richard to start and work through Thomas and then Aaron. What, if any, legal options are available to private parties who have a local government that is not behaving itself and allowing inappropriate development in coastal areas? So are there legal options for private individuals if the local government is not doing what it should be doing? Richard, you want to tackle that?
I'll let Tom address the liability issues, but if it's, that comp plan language, the comp plan isn't doing a good enough job of preventing bad development, the standards of the plan are inadequate, that's difficult. You probably need to wait for the next EAR report or wait for the next plan amendment that has some direct implication for sea level rise, vulnerable development, and advocate and potentially legally challenge that plan amendment on the basis that it's not based upon the best available data regarding sea level rise. If it's a development order being approved and you think that there's language in your comp plan that arguably that development order is violating relative to sea level rise, then obviously you've got the legal cause of action to challenge development orders in circuit court on the basis that they violate comp plans. And then I think that Thomas can talk about the potential liability of approving development.
Well, I mean, yeah, clearly I think Richard pointed out if you're approving development in violation of your comp plan, you've got a great case for challenging them there. I guess similarly to what Richard was indicating about the comprehensive plan, you might also want to find out talk to your floodplain manager and find out if some of these developments are in floodplains, and if so, what type of floodplain management rules do you have? Because very often communities, if they're going to participate in the National Flood Insurance Program, are required to have certain minimums in their floodplain management, and if they don't comply with those minimums, then potentially they can be decertified or kicked out of the National Flood Insurance Program, and local governments are not going to want that to happen, because then everyone loses flood insurance within their jurisdiction. So you might want to check into that too and find out if there is a floodplain issue there and whether or not their minimum floodplain management requirements fulfill the FEMA minimums.
Okay, thank you. We have a question about the impacts of relocation on interior communities in Florida. Are any of you aware of any interior communities, Florida or elsewhere, that are starting to talk about this issue, or is that not on the radar screen yet?
Well, this is Erin. I mean, most of the communities I work in are coastal communities at this point, so I can't point to a specific example. I do know some communities, interior communities, are having the discussion about increased flooding impacts and what that may mean to them, not just from like sea level rise, but precipitation and those types of events. But I haven't really seen many interior communities, at least in my experience, start having that discussion about what it means. Now, I have seen some of the coastal communities talk about what it means from an east-west or a west-to-east perspective when people within their community may want to move further away from the coast. But maybe Tom or Richard, if you guys have worked in other interior communities, but I haven't seen much of that discussion taking place.
Yeah, I can't say as I've worked with many interior communities that I've heard that, but I have heard, it's interesting, up in northeast Florida, they are specifically talking about the potential business opportunities of people that are having to move away from more vulnerable parts of the state. They say flat out, look, we've got a little bit higher area than a lot of places. If we really plan effectively, we can create greater growth and opportunity in a safe way here, and we can be a place for those that are dislocated to move to.
Okay, great. Thank you. We have a question. Is there any requirement for state or local governments to inform the public so that vulnerable communities don't have the impacts we saw as a result of Hurricane Katrina? And I think they're talking about lower income and sometimes minority communities that are, often in low-lying areas that might have these impacts. Is there any requirement that state or local government notify people in those communities of this? Thomas, if you want to take a handle on that.
Yeah, I know there really isn't much out there.
Okay.
For that I'm aware of.
Okay. We have one or two more questions. This is again about the issue of abandoning property. Can zones be created to address potential properties that will need to be abandoned rather than litigate on each property individually? Perhaps identify a useful life for these land areas in their current use. I believe Miami Beach is starting to do that. Is anybody familiar with communities starting to identify areas that might potentially need to be abandoned or rezoned? Erin, maybe you want to start with that?
I haven't seen any communities take that step so far. I know in the work that we've done in Monroe County, we actually looked at a community, an island community within the Chesapeake Bay that was subsiding, this island community, and they literally ended up having to abandon it. It was in a park kind of state of affairs for many years, and there are still some old structures out there. But I'm not seeing any Florida local governments at this point change zoning or look at that issue to that extent.
This is Vivian again. I do believe that Miami Beach is identifying areas that are going to have issues. I don't think they've gone to the point of rezoning or anything, but I do think it is on their radar screen. What will happen with it, I don't know. We have another question. Is there a state requirement for sea level?
Vivian, if I could jump in and add something there. I'm not sure if this is what you're referring to, but some of these, there are communities that are beginning to identify adaptation action areas, and I know that, for example, some of the communities in South Florida that are doing that are specifically indicating that an adaptation action area, in their view, is not delineating an area that they're going to abandon. It's actually delineating that area in order for them to focus resources on the infrastructure improvements required to assist that area.
Okay.
So even though they're calling them adaptation action areas, it's in some ways actually kind of the opposite of giving them up.
Okay. And this is kind of a related question. Is there a state requirement, quote, for sea level rise consideration in infrastructure investments, unquote, or is this only in adaptation action areas? So in other words, is there a requirement that all communities do this, or is it only in adaptation action areas, which are self-nominated?
I would say that the requirements in Chapter 163 related to the infrastructure elements across the board have to be based on the best available data and analysis, and across the board have to have policies related to environmental impacts, et cetera. So the short answer is no. That is not just limited to AAAs. All infrastructure is subject to the general requirements, and so if the character of the land they're going into, coastal high hazard area or subject to sea level rise or whatever, is it's inconsistent with that data and analysis, or it violates the substantive standard for the results of a plan, the required objectives or policies, it could violate the law.
Okay, thank you. We do have a statement that currently Broward County storm modeling is looking at inland areas and the effects of higher groundwater elevations on the ability to move stormwater, and is incorporating priority planning areas in its comprehensive plans. That maybe addresses part of it. We have a lot more questions and only a few more minutes. We're actually run over, so I'm going to ask one or two more questions here, and then we'll have to take it offline. Are there any movements by private owners and or condo associations to address issues post-destruction? And what they're talking about is if local regulations will now only allow 20 units to be rebuilt of a 50-unit development after a storm destroys the property, how will owners deal with this? So if you have a condo and 20 units are destroyed and it's a 50-unit development, is there any thinking about impacts like that?
Well, typically those types of structures are actually guided by their own internal documents. They're usually the condominium association documents are going to have different, there are actually ways within the documents to actually end the condominium or whatnot. So usually that's going to be controlled internal to their own documents. There are some defaults in state law for issues that are not necessarily covered by their documents, but again, I think in most cases it's going to be within their own private documents. Okay.
We do have other questions, and we are reading them. I apologize that we're not able to get to all of them, but we are running a little bit late. I did want to mention a couple things. If you go to our website, there's a lot of discussion going on about Broward County. We did have a webinar in the fall on what Broward County is doing. They are definitely one of the more progressive communities in the state in terms of what they're doing, and you can access the PowerPoint and see information on the programs that they're doing. I also wanted to reiterate again that we'd like our page to act as sort of a clearinghouse, so anybody who has links to other information, again, Florida-specific preferably, we'll be happy to post that and get a new link out next week. We did have one technical question about whether everybody receives a certificate of attendance. That's not needed for planners and attorneys. It is needed for some of the other categories. So if you do need a certificate, send me an email at vyong@1000fof.org, and we will get you that certificate for your credits. Do we have any final comments from any of our panelists before we sign off? Richard?
I'll jump in. Based on what you just said, I do a lot of work with Broward County in this regard. I think if they were on the phone, they'd be the first to say, now we do most of our work through the Southeast Florida Regional Climate Compact. They would probably want to share that praise with Palm Beach County, Miami-Dade County, and Monroe County. And one of the things that Climate Compact has been doing that I think is most valuable is they have now begun the process. They had 3 pilot areas where they had these redesigned charrettes. One in Doral, I think one in Miami Beach, one in Southwest Broward, I believe, I could be wrong, but where they looked at these areas, applied the data about projected sea level rise, and started translating that to potentially new land uses and densities and design and that sort of thing. So that's where most local governments, probably need to be going in that direction, and there's a pretty good model there.
Okay, Thomas.
Yes, and this is. I would like to say that in addition to the work being done in southeast Florida, there's a lot of different work going on in many different parts of the state. And for example, up in northeast Florida, I kind of hinted earlier, the Northeast Florida Regional Council is leading a process up there that's primarily being driven by the business sector. And again, they're focusing really on the future opportunities of these challenges for the business sector. And you've got, of course, work that's been going on for many years down in Punta Gorda in the southwest portion of the state. Satellite Beach has been working on sea level rise beginning in 2007, and they've done a tremendous amount of work there. Number of different communities incorporating this language about sea level rise and even climate change into their comprehensive plan. So there is a lot occurring around the state of Florida.
Great. And Erin, anything you'd like to add?
Just that it really starts with the information gathering and the data, and it doesn't take some big onerous process to really start getting some basic information about your community vulnerabilities. I just listed a few of those tools, but there are many, many out there. Climate Central has some good mapping and evaluation tools, and it doesn't take precise data and information. It just takes kind of a willingness to start identifying what those vulnerable areas will be, and just to start that conversation, it doesn't take a whole lot of money and effort.
Okay, and Charles, anything you want to add to this?
Well, just to conclude, this was something both Richard and our Erin mentioned, and that is that we actually see sea level rise mentioned 3 times now in Florida statutes, and that's by, a conservative legislature. So I think, information is getting out to people that need to see it.
And we did have an earlier question about DEO offering some community resiliency grants, and I also believe the Department of Health has recently done some work in that area. So we are seeing state programs, and again, if you go to our climate change page, we do have a link to the PowerPoint from our fall webinar, which outlines state resources on climate change, so we encourage you to take a look at that. Well, I'd just like to wrap up and thank all of our speakers, especially for staying overtime, and for all the people who stayed on the line. I think this is a really critical topic, and one that obviously there's a great level of interest in. So we thank you all. We will be sending an updated link out with updated information in the next week or so. And again, you'll be receiving a email about an hour after this webinar with a link to SurveyMonkey, and we ask that you give us your feedback. Thank you very much, and we hope to see you at our next webinar next month. Goodbye.